Honorable Chief Justice and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Well, good morning. This is the second day of our October call. We have 3 cases that we'll be hearing this morning. Then we'll be returning in the afternoon. As always, there'll be 30 minutes per side for grants and 15 minutes per side for arguments and application. First case we'll hear this morning is People versus Tia Marie Mitchell Skinner. My understanding is that you are going to share your time with the Solicitor's office. Is that correct?
That's correct, Your Honor.
And roughly how much time do you expect you'll each have?
Your Honor, I would ask to give Mr. Rastuccia 10 minutes of my time and then also reserve 3 minutes for rebuttal.
Okay. So. As you know, you're responsible for monitoring your own time, however.
Yes.
Okay. Please proceed. Thank you.
Good morning. May it please the Court, my name is Hillary Georgia, and I represent the people of the state of Michigan. The Sixth Amendment does not require a jury to determine whether a juvenile can be sentenced to life without parole because there is simply no fact that must be found before life without parole can be imposed. Life without parole in Michigan is authorized by the jury's verdict alone and the facts found therein. The case of Miller v. Alabama requires only that a sentencer consider a juvenile offender's youth and attendant characteristics before determining that life without parole is a proportionate sentence. What Miller did not do is require the finding of any particular fact, and in implementing Miller in our state, MCL 769.25 does not require any finding of fact either before life without parole can be imposed. In interpreting the Miller decision, the United States Supreme Court said in Montgomery that Miller did not impose a formal fact-finding requirement. It has been suggested by my opponent that irreparable corruption or incorrigibility is a finding of fact that must be found before life without parole can be imposed. But this is not the type of formal fact-finding that is of Sixth Amendment significance. Something like irreparable corruption is really an ultimate conclusion or a term of art of a sentencing court after exercising its discretion within a range of available sentences, life without parole being one of them. In reaching a decision whether a juvenile is or is not irreparably corrupt, a sentencing court may indeed make factual findings. They may be factual findings about the defendant, they may be factual findings about the case. But where factual findings do not result in a change in the range of punishments, either at the low end or the high end, factual findings by the court in the sentencing process are not improper and do not violate the Sixth Amendment. Such is the case here. Life without parole is available at the time of conviction as the maximum. When our legislature enacted 769.25, this merely provided a process by which Miller could be implemented in our state, not a factual prerequisite. This conclusion is supported by 2 of the main cases discussing the Sixth Amendment in the context of sentencing, and the first one being the Apprendi v. New Jersey case. And I quote the court in saying, "We should be clear that nothing in this history suggests that it is impermissible for judges to exercise discretion, taking into consideration various factors relating both to offense and offender in imposing a judgment within the range prescribed by statute. We have often noted that judges in this country have long exercised discretion of this nature in imposing sentence within statutory limits in the individual case." This same sentiment came about in Elaine v. U.S., where the court said, "Our ruling today does not mean that any fact that influences judicial discretion must be found by a jury. We have long recognized that broad sentencing discretion, informed by judicial fact-finding, does not violate the Sixth Amendment." MCL 769.25 does not infringe on the Sixth Amendment rights of defendants as extended by Apprendi and Elaine because it simply does not expose a criminal defendant to a penalty exceeding the maximum of what he or she would receive if punished in our state according to the facts reflected in the jury verdict alone. And the issue before this court really turns on the question, what punishments are available to the sentencing court based simply on the jury's verdict? And in Michigan, under 750.316, first-degree murder is punishable by life without parole. And obviously Miller changed that, 769.25 changed that, and made that a lesser punishment or a term of years available for juveniles. But all that statute does is give two different routes by which the court can reach a sentence. The first being the term of years of 25 to 40 up to 60, and then the second being the life without parole, where the court is legally authorized to sentence up to that as the maximum. There is a provision or a process by which the prosecutor can file a motion seeking that maximum, but that does not add an element of proof or any additional facts that need to be found. It's simply a step in the process, a way for the prosecutor to show that it intends to seek the highest sentence allowable. Neither the filing of the motion nor the consideration that must ensue of the Miller factors after a motion has been filed rises to the level of a necessary factual finding that increases a punishment under the Sixth Amendment requiring impaneling of a jury. Regardless of the prosecutor's motion, any juvenile that commits homicide in the state of Michigan knows that they are subject to the possibility of life without parole at the top end. Regardless of the prosecutor's motion, the law allows for this, and the motion really is only a notice of whether the prosecutor is seeking that punishment or not. I think it's also worth considering for the court today that the Miller factors have always been factors in mitigation, not in aggravation. And under the Miller decision, which our statute mirrors, these mitigating factors are not things that need to be found by a court. When the sentence starts out at the top as life without parole, these mitigating considerations bring the sentence down, and that's not something that requires a jury finding. The use of the word aggravating in the statute doesn't change that, because the statute mirrors Miller, and Montgomery tells us that Miller does not require formal fact-finding. Findings of fact, in addition, are generally somewhat binary. They either are or they are not, but mitigating factors are not quite as finite and not quite as specific. And that's why when you look at mitigating factors, you generally you see considerations that are more broad than what we're looking at in some of the cases that were cited by I guess both sides in this case. Those cases consider specific. I'm sorry, Your Honor.
Counsel, the statute that we're dealing with here from Michigan requires that the prosecutor affirmatively move if it's seeking a life without parole sentence. It requires the trial court to affirmatively consider a variety of Miller factors. It requires that the trial court specify the mitigating and aggravating circumstances that it is in fact considered, and it requires that it provide reasons for its decisions.
Correct.
Doesn't that kind of statute, with that kind of language, with those kinds of requirements, at least implicitly and effectively require the trial court to make findings of fact as a prelude to the imposition of a life without parole sentence?
I think that in making the decision of sentencing, the court necessarily does find facts, but the significant point for Sixth Amendment purposes is nowhere in this statute does it say that the court has to find one or any combination of facts in order to have life without parole. And I think if I understand the court's question, I would agree that the prosecutor's motion does come before the court can reach that conclusion, but that's merely a matter of process. That's there to give notice that that the prosecutor is seeking life without parole. But at that point, after that motion is filed, this statute only tells the court that it has to do the same things that Miller tells us that we have to do. We have to consider these factors. And when we talk about the court having to specify in the record the aggravating and mitigating factors, I think that that's...
You have to consider the factors for what purpose? What's the point of considering the factors?
In order to arrive at an individualized proportionate sentence for a defendant. But looking at those particular circumstances, whether you want to call them considerations or circumstances or factors, Miller requires us to look at that, but neither Miller nor the statute says you have to find that one of these things exists before you can impose life without parole. Life without parole is always there and always available.
Sure. So what if the statute requires that the prosecutor file a motion and state reasons for why the prosecutor is seeking life without parole? So what if the court decided that it disagreed with every single one of the prosecutor's reasons but still imposed life without parole? What should an appellate court do in that circumstance? Would the appellate court be required to reverse the judgment?
I don't think so, no, because I think, again,
why not?
Miller doesn't give you specific factors that have to be found. If the court were to listen to all of the presentations from the prosecutor and from the defendant and find that none of these reasons why the prosecutor was seeking life without parole existed and then imposed life without parole, the standard of review there is really just to review it, is it reasonable, is it proportional? And if the court were perhaps considering other factors, maybe things the court had heard at trial or things in the defendant's past that found that those things really weighed in favor of life without parole, as long as it's a proportional sentence and as long as the court has considered any mitigating information that the defendant wants to bring forward, that's where the appellate review is. I mean, it's not. But you would, so even if, but on your hypothetical, the prosecutor says, I think life without parole is required for reasons A, B, and C. Mm-hmm. And the court says, well, I reject A, B, and C as reasons, or I don't find that those facts are true, but I find fact D. What if the court didn't say, but I find fact D? The court just says, yeah, but I don't find any of these mitigating facts, therefore life without parole. Well, the court, under the statute, can consider any other criteria relevant. So as long as the court is considering something, I mean, if the court is just arbitrarily deciding to impose life without parole, obviously that runs into an Eighth Amendment problem, not a Sixth Amendment problem. I mean, that's a sentence that's not proportionate to the individual and it's not individualized, and that was the focus of Miller, was that Eighth Amendment problem. So I think under your hypothetical, if the court were to listen to the prosecutor's reasons for seeking life without parole and not make any conclusion as far as whether there was anything mitigating for that juvenile, I think that's where that sentence would run afoul of Miller, because the court wouldn't have considered mitigation. So it would be reversible as a matter of the Eighth Amendment, but not as a matter of the Sixth Amendment, even though probably some fact or factor must tip the balance one way or the other, must tip the balance towards the finding of life without parole. I agree it would be an Eighth Amendment problem. And again, that's why when I started out with the quotes from Elaine and from Apprendi, there is no problem with judicial fact-finding within a range. And that, to me, is what this is. If we're, again, dealing with aggravating factors, you know, if this defendant is coming in with the sentence in the statute saying you will get a term of years unless an aggravating fact is found by the court, that's a completely different story. But the way the statute is written and under the hypothetical you've given, the only issue that court would have would be an Eighth Amendment. They'd probably get reversed, but not reversed on Sixth Amendment grounds, reversed on Eighth Amendment. No, Eighth Amendment grounds, yeah, because it wouldn't be individualized, it wouldn't be proportionate, and that is really the heart of Miller. Miller is not about the Sixth Amendment or about fact-finding. It's about making sure that an individual's characteristics are considered before imposing the harshest penalty available.
So does it follow then to comply with the Eighth Amendment, the court is going to have to find some facts that justify the life without parole sentence? Is that so? It sounds to me like you don't think a court can say, I have, at the end of one of these hearings, I find no mitigating factors, life without parole. You think that would be a reversible, Eighth Amendment reversible sentence?
I think in light of the part where the statute instructs the court to specify on the record any factors that they found, that might be a little thin. But they don't. If they don't find any factor either way.
No, my hypothetical is the court says, I find no mitigating factors, so you are sentenced to life without parole. Does that violate the Eighth Amendment?
I don't believe it does, so long as what preceded that was a consideration of those factors. I mean, I don't know that we can ever get inside, you know, the judge's head and see, did they truly weigh out, you know, the facts in front of them. But I mean, if you have a Miller hearing and if the defendant is given that opportunity to present all that mitigation, and the court comes to the conclusion that life without parole is the appropriate penalty, then you know that obviously it's reviewed. But I don't think that it's a problem.
So anytime a judge says, I find no mitigating factors, you're sentenced to life without parole, the judge will, that sentence will be protected, will satisfy both the Eighth Amendment and the Sixth Amendment, it sounds like.
I believe so, as long as the Miller proceeding has taken place. I mean, it's not, I don't think Miller guarantees a juvenile a sentence of a term of years. I think Miller cautions us, obviously, that it would be a rare sentence, but all Miller requires is that the juvenile have the opportunity to present the court with mitigating evidence. And if that mitigating evidence isn't compelling for the court, you know, based on what the court knows about the offense, or, you know, if it's not compelling for some other reason personal to the court, Miller just requires that they have the opportunity. It doesn't command a particular result of that hearing.
So while there's no obligation to affirmatively identify aggravating factors in your conception of what's required, no affirmative obligation, and the prosecutor can yet pursue a life without parole sentence, once a mitigating factor is identified, that imposes an obligation upon the prosecutor, if he continues to choose to wish to pursue a life without parole sentence, to identify some aggravating factors that presumably trump or overcome in some way the mitigating factors. Is that right?
I think that Miller makes the mitigating factors something that the defendant has the ability to bring forward. I don't think the statute really provides for any type of burden there, but I think when the statute tells us that the prosecutor should specify grounds, that's more of a notice to the defendant of what the prosecutor is getting at or why the prosecutor thinks that they should have a sentence of life without parole. I think... So the mere identification of mitigating factors still does not impose any burden on the prosecutor to identify overriding aggravating factors in order to pursue life without parole. I don't think that the statute imposes a burden on the prosecutor to do that. If I could qualify that, though, I would say that most prosecutors generally would. Obviously,
I don't understand what that means, that last statement.
If a prosecutor has filed a motion seeking life without parole and specified, the statute calls them grounds, reasons why the prosecutor thinks that life without parole is appropriate, if the defendant comes forth with mitigating considerations for the court, I would expect that the prosecutor's office would probably counter that. I just don't think the statute requires it or places a burden. Does that, I don't know if that clarified, but I think generally the prosecution is, if they're seeking a particular sentence, and especially the sentence that is the highest one available under the law, the prosecutor is always going to make a case for that. But the statute doesn't require it. Beyond the notice requirement, which again requires the prosecutor to state some grounds, and I think presumably that's just so that the defendant can respond to those grounds and bring forth also any other mitigating information that he wants to bring forth. But the statute, the way I see it, at least in my reading, does not provide a burden at all.
So unlike in the death penalty or the capital punishment context, there's no obligation to balance in any way the aggravating and the mitigating circumstances?
No, I don't believe that's there. I mean, I think the court has the obligation to consider all of that evidence. I mean, the statute tells us that the court has to consider all these factors as well as any other criteria relevant, but I don't believe that the statute establishes a burden.
Counsel, does the court have to conclude, I don't know if it's I want to ask you, does the court have to conclude that the juvenile is irreparably corrupt or one of the unique cases? Does the court somehow have to articulate that it has, having thought through the potential mitigating factors or mitigating and aggravating or Miller and mitigating and aggravating, I'm not sure exactly what the court's supposed to do, that it finds that this particular defendant is one of those unique or rare cases where there is irreparable corruption? Does the court have to make that determination?
I'm sorry, I didn't.
Go ahead.
I didn't mean to cut you off. I don't think that the court has to say, I find that this juvenile is irreparably corrupt. I think, again, irreparable corruption kind of emerged from these cases, and we referred to it kind of in discussing and preparing for this as kind of a term of art. I mean, it's a conclusion. And a defendant, a juvenile defendant can be irreparably corrupt for any number of different reasons or circumstances or ways. So to say the court has to find that this defendant is irreparably corrupt, I don't think that it can do that. I mean, the court can find a number of different things.
So the court has to find the underlying facts, factors, evidence that supports that legal conclusion? Is that how you think about it?
I think of it as a sentencing conclusion. I mean, the court's going to arrive at a sentence that it feels is proportionate and appropriate for each juvenile. Some it will be that term of years, some it will be life without parole. And I think that the term irreparable corruption is kind of it's kind of a guideline or a standard for the court to look to in considering all these factors. And do those generally amount to a juvenile that's irreparably corrupt, or do they not? But I don't think, and it's not just a matter of what I think. I mean, and Montgomery tells us there is no formal fact-finding requirement. And I think if they wanted us to find formally that someone was irreparably corrupt, they would have told us that. I'm looking at my timer, and I do want to pass it on to Mr. Astucia. Thank you.
May it please the Court, Eric Christusha from the Attorney General's Office appearing as amicus. I think the way the Court should think about the sentencing proceeding is one in which the trial court has two options, life without parole or a term of years. And we know from the standard that the question is, does any required finding expose the defendant to a greater punishment than authorized by statute? Statute authorizes both sentences, but the Eighth Amendment requires the sentence to be proportionate. So all the case law, the statute, talks about considerations. The trial court considering these individual factors. What it's requiring the trial court to do is show its work. So there's a record that can then be evaluated for an Eighth Amendment evaluation. But the Sixth Amendment, the narrow question for the Sixth Amendment is there any required finding that exposes the person to a greater punishment? And the court was clear, in Montgomery it said Miller did not impose a formal fact-finding requirement. In fact, it also said there's no requirement that there be a finding of incorrigibility. So really, the court could do this. I considered X, I've considered Y, I've considered Z, and I think that the appropriate sentence is a life without parole sentence. That would be adequate under the Sixth Amendment. Now, what's going to happen on appeal, and that may not be a very good record for the Eighth Amendment, but let's say it's a terrible case. I know out of St. Clair County, they have a 1987 murder, Mr. Porter, who murdered a whole family, 5 people, including an 8-year-old child. That's one of their cases, right? Let's say the fact record was kind of weak, but if we're looking at that on appeal, we're going to say, is that not a proportionate sentence? We're going to think, well, he considered the factors, he's met the Sixth Amendment, it's been satisfied. Is there an Eighth Amendment violation? No. This is one of those rare cases that the sentence is appropriate.
Have you waived free fire? I'm sorry.
Oh, yeah, no, I don't have a free fire, so.
Okay. But you aren't saying that considering the factors is required for the Sixth Amendment.
Well, it's for the individualized sentence. The process, the Sixth Amendment,
really?
The question,
that's a Sixth Amendment question?
Well, maybe I'm wrong on that. I think because it's kind of the Miller and Montgomery are Eighth Amendment cases.
It's certainly required to comply with the statute.
So it seems to me for the Sixth Amendment, we look at the requirements that the statute imposes. The statute doesn't impose any fact-finding requirements. There may be fact-finding, but of course I think that the quote that Ms. Georgia gave us from Apprendi is exactly right, that if there's fact-finding within the range that's authorized by statute, that's not a problem. The Sixth Amendment has a problem when we say this fact unlocks a higher sentence. There is no required fact. And if you think, I think one of the, if you look at the Pam amicus brief from Mr. Boffman, one of the things he raises is what would the verdict form look like for the jury? Because if you look at the Miller factors, they're not really binary, and that's, I think, they kind of are maybe mitigating, but they're not even that. Because if you think about, I'm required to consider the home life of the perpetrator and make a decision whether it's appropriate to give a life without parole sentence. Well, if I consider the home life, it may be reducing culpability, right? He's had a terrible home life. But if I'm concerned about incorrigibility and rehabilitation, maybe a terrible home life actually cuts against the possibility of getting a term of year sentence because it maybe show it's so ingrained that this is a person that's not going to be reformable. So in a way, these are just considerations, and that's how the Montgomery case reads. Consider, take into account. That's all that the statute requires as well, since there is no fact that is the threshold that unlocks a higher sentence, there is no requirement that there be a jury.
Counsel, this whole thing feels like my head gets, it feels like a question begging, like, problem. I mean, it sort of depends on how you ask the question at the front end. So I guess I imagine the statute just said, in these cases, the defendant can be sentenced to a term of years, life with the possibility of parole, or life without the possibility of parole. Then I think they'd probably be here with an Eighth Amendment challenge to that statute. But putting that aside for a second, I think all of the things that a court might consider are just the regular things a court considers in the range of, potential sentences. And we probably wouldn't have we probably wouldn't have much to talk about in terms of a Sixth Amendment question, right? Or maybe nothing to talk about.
Right. I don't think, in a way, I don't think that's so different from what this statute does. But
well, I want to hear why, because it seems to me that at the end of a trial under this statute, if the prosecutor does nothing, the court cannot sentence a defendant to life without parole. Is that correct? Unless there's this notice.
There has to be a motion. That's certainly the case.
Right.
But that's not a fact finding. Obviously, that's a procedural mechanism.
I'm just trying to understand why the statute is different than the hypothetical one I gave
sure.
you.
Right. There is a requirement that the prosecutor file a motion.
The prosecutor has to file a motion, and then the court has to consider, according to the statute, the Miller factors, like you said, whatever those are exactly, any other aggravating and mitigating, factors. And so the court has to do all these things before life without the possibility of parole is a potential sentence it can get to. And I'm just wondering if...
I don't think that's true. I think that last characterization, after the motion's filed, if you look at the statute, in a way it presumes that you start with a life without parole sentence, because subsection 9 reads, says if the court decides not to sentence the individual to imprisonment for life without parole, then term of years. In a way, the statute, if you take it on its face, almost starts with, well, I mean, I'm authorized to give you life without parole. Should I do that? Now, what the statute is doing with respect to those Miller factors is complying with Miller, which Miller says our sentencing courts should consider these things. Well, that's true of any sentence, frankly. They didn't have. Miller says, I know we have these other cases where there have been the defense bar saying we should have the Miller factors considered at other hearings for 17-year-olds who commit crimes. Well, of course, you always consider this stuff, right? I mean, this is the stuff that's true of every sentencing. We could say this. I mean, we could put this in every statute for which there's a discretionary range and say, do this, consider this. We're just expecting our trial courts to do their job, right? Well, here we've outlined it because the Miller case came down and we had to change our whole scheme, so now we've actually put in writing, consider the Miller factors. Do what the United States Supreme Court said. But that's really in order to comply with.
But there's something missing there. This is kind of a totality of circumstances kind of test that we have Miller imposing. But every totality of circumstance test, consider all these factors, consider all those factors. There has to be attached to those kinds of considerations some attendant ultimate question. Okay, I've considered them, I've placed them in a pile before me. Now, what is the ultimate question that all those circumstances are designed to allow us to reflect upon or decide or consider in some kind of ultimate way? What is that ultimate question when you've piled up all those circumstances before you, you've considered them all, and you have to bring them to a culmination? What is it you ask yourself? What does the judge ask himself or herself?
The standard of decision is ultimately irreparable corruption. If I'm a sentencing judge, I'm looking at irreparable. That's what the court has said. The court has made it pretty clear. As a class, transient immaturity, it's barred. It has to be people who are irreparably corrupt. But that is like the court has just equated that with proportionality. So when I say irreparable corruption, it's just like saying the sentence has to be proportionate.
So a judge considers things and he asks himself, what again at the end?
He asks himself,
do they amount to what?
Irreparable corruption. But it's not a discrete fact. And the reason it's not a discrete fact is this is not a formal fact-finding process. The Sixth Amendment does not, under the Sixth Amendment, there is no required finding. When we look at it under the Eighth Amendment prism, we have to then think, is this something where a judge acting within that judge's discretion could reasonably conclude that this person was irreparably corrupt? They don't have to use the magic language. Ultimately, we look at the decision itself with respect to the crime and make some decisions. Like for Ms. Skinner's case, we think, someone who has her father murdered and attempts to murder her mother when there's been no abuse, there's no mental illness. That's a very unusual crime. You can be in criminal prosecution for 25 years and you won't see cases like this. You don't, right? It takes your breath away. The reason St. Clair County comes and brings all of it, because they are deeply concerned about this case because of its unusual malevolence, right? So let's say our trial court, I think Judge Kelly has done a good job and created a good record. But let's say he didn't create a good record. All he has to do, though, is consider these factors. And once he's done that, he's complied with the statute. And then once he's complied with the statute, all we're left with now is an Eighth Amendment analysis. But under the Sixth Amendment, there is no required findings. That really is the beginning and end of it. It has to be that there's a presumption of another sentence in the absence of a fact. And here there is no predicate fact required. The Court has reiterated the point. The quote from Montgomery out of the box is, Miller did not impose a formal fact-finding requirement. You don't have to make a fact-finding with respect to incorrigibility. And as a consequence, this is a sentencing judge's decision. There's still time for rebuttal.
Just kind of an irritating obligation the Supreme Court's imposed upon the judicial process.
All it requires is, in fact, because we think these are important cases since they involve juveniles, we're going to require you to show your work because then we'll have a better record for an Eighth Amendment analysis to a review on appeal for abuse of discretion. Now, I still have a minute and a half for Ms. Hillary, Georgia, for rebuttal.
A minute 32. Go on, please.
Good morning, Chief Justice Markman and Justices of the Michigan Supreme Court. My name is Kim Thomas. I'm here with co-counsel Frank Vandervoort on behalf of Tia Skinner. We're here today because MCL 769.25 violates the Sixth Amendment and due process right to have a jury find the facts beyond a reasonable doubt that are necessary to the greater sentence of life without parole. I would waive the uninterrupted question period and welcome questions as necessary. I'll start today with the statute itself because the Sixth Amendment requires us to look at the statute that we're examining under the Sixth Amendment and Due Process Clause. On the four corners of a jury verdict under this statute, the juvenile can only receive a term of year sentence. There's no other sentence based on the four corners of the jury verdict that the youth can receive. And Blakely tells us that when a judge inflicts a punishment that the jury's verdict alone does not allow, the judge has not found all the facts which the law makes essential to the punishment, and that exceeds the court's proper authority.
So what is the fact that you, because remember, we've gotten a long ways from Apprendi, but if we go back and we think about Apprendi is about not allowing legislatures to convert elements of the crime into sentencing criteria for judges. And so what is the element of the crime that you think the prosecutor needs to show beyond a reasonable doubt in order to satisfy this statute? I think that's I can't quite get my head around.
Yeah, so the prosecutor, as Mr. Vasuccia says, needs to show irreparable corruption. That's the ultimate fact that needs to be shown here.
So the prosecutor must prove irreparable corruption beyond a reasonable doubt.
That's correct.
Is there any? So do you think that's a factor about a fact about the offense or a fact about the offender?
The Eighth Amendment language would suggest that it encapsulates both. So it's, the language, Montgomery language is that it's only a permissible sentence for the rare offender whose crime reflects irreparable corruption, and so it does seem to include both of those.
So I see. So pieces of it could be about because the thing is, as I think about all the Apprendi cases, I can't think of a single case in which the Supreme Court has held that an offender characteristic is an element of the crime. So committing murder while irreparably corrupt. I mean, committing murder or robbing a liquor store with a firearm, that's a fact. With a firearm is a fact about the offense. But I can't think of a single one where it's an offender characteristic. You think about Almendarez-Torres, they said, oh, no, not that one, not being a recidivist.
Well, they have looked to offender motive in committing the crime, which I think in some ways is a little bit certainly in the grayer space than just,
I agree with that.
An external fact about the offender. If you look at the pleadings that the government has filed in these cases, they're allegations of what they're going to prove. Some of the counties have said they're going to prove irreparable corruption. Some have specified other intermediate, what they call aggravating circumstances, such as the brutality and depravity of the murder. So they are saying that those aggravating factors that they're going to show in their motion, that they're going to show at that hearing, lead to the conclusion of irreparable corruption. And so that's really the important thing, to look at how this statute works. What happens is the government, after the conviction, files a motion with these aggravating factors that it intends to show. The statute requires a hearing on that motion. The statute has evidence presented at that hearing, and during that hearing, the court is required to state on the record the aggravating and mitigating circumstances that it has considered. So this isn't a situation where the court has broad discretion to do whatever it wants. It's a very constrained statute that tells the court you have to have a hearing on this motion, and the result of this hearing is these fact findings that results in the question of whether or not there's irreparable corruption that can permit the greater sentence of life without parole.
Counsel, do you agree with me that in my hypothetical statute, if the legislature instead, putting aside any potential Eighth Amendment concerns you would have with my hypothetical statute, if the legislature had just said the juvenile can be sentenced to, the defendant can be sentenced to a term of years, life with the possibility of parole, life without the possibility of parole, under that statute, you wouldn't be here with the Sixth Amendment objection?
That's right. I wouldn't be here with a Sixth Amendment objection.
I expect you to be here with an Eighth Amendment.
I might be here with an Eighth Amendment, but no, that doesn't implicate the Sixth Amendment. What implicates the Sixth Amendment is the statute's grounding on the four corners of the conviction in a term of your sentence, and the allegations and subsequent hearing and fact-finding that are required in order to permit the court to give the aggravated sentence.
So why is Mr. Restuccia wrong, though, about the way we should view the statute? That really the statute, at the front end says life without the possibility of parole is always a permissible sentence. In fact, it's the sentence you should expect unless there's some mitigation. And if this is really, this all feels like a framing question to me. If it's murder minus something, we don't have a Sixth Amendment problem, right? If it's murder plus, we do. So why isn't he right about how we should think about this?
So maybe a different way to think about it is if we have Ring, right? In Ring, the government alleges aggravating circumstances, but just on the fact of the alleging of those aggravating circumstances doesn't permit the death penalty in that case, right? So here the allegation by the government of their aggravating factors doesn't permit the greater sentence of life without parole. There has to be the subsequent hearing and fact-finding by the court that then expands the range of punishment to a greater sentence. So, or in...
I'm sorry, were you?
No, go ahead.
But in Ring, the statute, the Arizona statute pretty clearly sets out certain facts. The murder was for pecuniary motive. The murder was heinous, atrocious, and cruel, or whatever the particular facts were, that a jury can easily find. Here, you want the jury to draw a broad conclusion about irreparable corruption, which could, I agree, like part of the circumstances of the murder could be factors to lead to that. It was particularly heinous, atrocious, and cruel could point towards irreparable corruption. But there are other things that might also point towards irreparable corruption, lack of remorse or, various other things. And I don't know how a jury finds those as facts. I'm struggling with, is this Ring or is this not Ring?
Right. So maybe it's, it's Apprendi or it's Cunningham, right? So in both Apprendi and in Cunningham, those statutes did not have a list of aggravating circumstances. So in Cunningham, the language was unless there are circumstances in aggravation or mitigation, right? It's very broad. It's very wide open. Same thing with Apprendi. Apprendi is there's no specific fact that the court or the statute is required to find. It's left to that fact finder, but it's that fact that's found by the fact finder, even if not specified in the statute.
But the underlying New Jersey statute in Apprendi said, was this crime committed because of hatred, animus towards a particular racial group or whatever. So there was there we had a statute where you can present a jury facts about the motive, and a jury can draw a conclusion this was or this was not done because of racial animus.
Mm-hmm. And so here, so I guess 2 points. One, the statute doesn't need to say so, and we have examples of Cunningham or Blakely, substantial and compelling reasons, right there. So there aren't the specified sort of finite, discrete facts. And two, really the ultimate question here is a question of irreparable corruption. And, obviously there would be, I think, a jury instruction written that would give that some additional clarity for the jury to determine, but that's the ultimate fact that needs to be found and is going to be the subject of these hearings no matter what.
And is that a fact the jury finds, or do you envision the jury being able to find these other facts from which the sentencing judge could then categorize them as equaling irreparable? What is irreparable corruption? Is that a moral? What is that?
It's a fact, Your Honor. Irreparable corruption is a fact. It shows the lack of potential to be rehabilitated. That's the language that another court has used into trying to sort of give some gloss to what irreparable corruption looks like.
Is it a statement of a past fact or a prediction of a future fact?
So I think, of course, juries can only decide what's in front of them in the moment, right? So they can say this.
Typically, that's what
jurors
and courts are best at, right? Deciding what happened before, not what's going to predicting the future.
So, can this person be rehabilitated in the future? I would expect there would be expert testimony on that or something like that in these hearings. But, can the person be shown to be irreparably corrupt? And Montgomery tells us that that's really the categories we need to be thinking about in terms of the Eighth Amendment, and to have our statute comply with that requirement, right? Because the Eighth Amendment doesn't permit substantively the sentence of life without parole to a youth who's not been shown to be irreparably corrupt, whose crime reflects transient immaturity. and the Eighth Amendment permits the sentence of life without parole to the rare offender whose offense reflects irreparable corruption.
Going back to your statement earlier about the four corners of the conviction, I think a lot in this case depends on whether we conclude, as the Court of Appeals did, that there's a default sentence here of a term of years, or whether there's a range of sentences, as Mr. Restuccia suggested. And you focus a lot on obviously the statute under the Code of Criminal Procedure that is at issue today, 769.25, but that doesn't create a substantive legal offense. And I'm wondering why we don't focus more on the first-degree murder statute, which creates the offense, when we're thinking about what the range of sentences are.
Sure. So the first-degree murder statute tells us for someone who's under 18 at the time of the offense that we're to look to MCL 769.25 as the governing law. It's just like in Blakely.
As a potentially governing law for the sentence, right? But it still doesn't change the substantive offense, right?
It's still first-degree murder. These are all first-degree murder cases.
And so the elements of the offense and so forth are all in that statute, which is in the penal code where you would expect them to be, right?
That's correct. So it's like in Blakely, where the governing, I think it was kidnapping statute, defines the maximum punishment at 10 years. The statutory sentencing guidelines then narrow the eligible sentence that's available. So it's the same kind of function. So here, 316 functions like the kidnapping statute in Blakely, and 769.25 functions like the statutory sentencing guidelines in Blakely that then create the default term of year sentence.
And does the procedural statute narrow the options? Or
it does.
Expand them?
So the procedural statute 769.25 says that upon conviction without anything else, that a term of year sentence is what's available to the court.
So I would be wrong if I concluded that it expanded the range of options in a way that's favorable to the defendant?
That's right. So there are, I guess, more sentences available to a young person than there would be to an adult. For an adult, it's mandatory life without parole under 316.
Can I just, I wanted to go back to Justice McCormick's question and just be very clear about what your answer to it is. So she asked how you envision this would play out in front of a jury and what it is that you want the jury to find. Do you want the jury to find, particular facts about the homicide offense? I'm looking at the Miller factors, the offender's chronological age and its hallmark features, and then the judge would decide from these facts that a jury found, maybe in a special verdict form or something, whether or not that adds up to irreparable corruption or not. But I thought you said, no, that's not right. The jury itself would find irreparable corruption as a fact. Is that?
That's right.
That's right. Okay.
Yes. So the jury would find irreparable corruption as a fact.
And so then the crime is homicide while irreparably corrupt.
That's right.
Okay.
The government puts a lot of weight on the language in Montgomery, and so I wanted to address that before the court today. They've emphasized this piece, and so Montgomery looks to the state of Louisiana's argument that, we haven't, it's not a substantive statute, it's a procedural statute, and so that's, of course, the debate in Montgomery. And the court says, we're not going to find, we're not here on this question, we're not going to find as a prudential matter that every single case it requires fact-finding. And so the court is saying, we're not going to hypothesize every imaginal state procedure that states might develop to implement our holding in Montgomery, and then say every single one of those is going to have a fact-finding requirement. And that would be appropriate, of course, for the court to not do that hypothetical exercise. On the other hand, we have in front of us, of course, a statute that, in fact, implements Miller and Montgomery, and that statute does require a fact-finding. Okay, so certainly, and the court pointed in Montgomery that a state could choose to implement the requirements by making every sentence parolable. If every sentence is parolable, there's no required fact-finding of irreparable corruption. That's not, it's not even a question at that point. So there are ways in which states could address the holding in Miller and Montgomery that do not require the finding of irreparable corruption. The method shown us by our state does, in fact, implicate that. And so the language in Montgomery doesn't control the answer to the court's question here today. The fact that the statute doesn't have any one particular fact or combination of facts, I think that the case law bears that out, but that was again mentioned today. There's no requirement that the statute itself specify a specific fact in order for there to be a Sixth Amendment violation.
Is that, but so one of my questions to opposing counsel was, can the judge have this hearing and at the end of it say, I find no mitigating factors, you're sentenced to life without the possibility of parole? Is that consistent with the Sixth Amendment and the Eighth Amendment from your perspective?
No, it's not.
Not consistent with either, or what would you be complaining to us about if that happened?
I would complain that as a matter of Sixth Amendment law, that there was no aggravating circumstance found, which is required, or aggravating circumstance put on the record that's required as a statutory matter.
But why does the statute require aggravation exactly? I mean, it says you consider aggravating but also mitigating. It says you consider the Miller factors, which also are sort of aggravating and mitigating. I mean, how do I know that aggravating factors need to be found to justify the sentence? That's exactly what I'm worried about, because if mitigating is enough, there's no mitigating, then we're looking at murder minus instead of murder plus, right?
Right. So I think the government wants to see this as a default, a potential default of life without parole. Right. And we can look directly to the language of Montgomery to say that that can't be, right? So Montgomery's language says, before Miller, every juvenile convicted of a homicide defense could be sentenced to life without parole. After Miller, that's not true, right? So we can't have the default of life without parole.
Per the Eighth Amendment.
Per the Eighth Amendment.
Right.
So we can't have a statute that implements the default of life without parole. We have to try to read our statute consistently with the Eighth Amendment, because that's what our legislature was trying to do.
So the Eighth Amendment has to be the Eighth Amendment background animates why we have to think about this statute as requiring some aggravation, some finding of aggravation.
I think we can look at the plain language of the statute, and then I think we can say what alternative ways are there of reading it outside of the plain language. I think the government is an alternative way, and if the whole point of it is complying with the Eighth Amendment, that doesn't comply with the Eighth Amendment.
What's wrong with the California appellate's description of irreparable corruption as not entailing an affirmative factual finding, but rather the term encapsulates the absence of youth-based mitigation,
so,
in which case there needn't be an affirmative or an aggravating factor, but merely the absence of mitigating factors. What's wrong with that description?
So the statute in California that was examined by that court was a statute that required murder plus already. So there was already a jury finding of an aggravating circumstance. Okay, that aggravating circumstance is not listed as irreparable corruption, but there's a murder plus already. And so the court is looking at now within that murder plus category the discretionary range. Okay? So here, if a jury finds irreparable corruption, a judge, so this isn't jury sentencing, a judge could have the authority to sentence to life without parole or a term of years, right? There is that discretionary range, of course, at the end, as all the case law acknowledges.
So I keep coming back to is this an element of the offense? And sort of a fundamental tenet of the way we think about crime, so we try crimes, not people. We try acts. We don't try people. And so we have a whole bunch of doctrines built around that. We keep out 404B evidence and all kinds of things. And when you say the element of the offense is irreparable corruption, murdering while in the status, we try to avoid status offenses, murder while in the status of being irreparably corrupt, it just seems like an odd thing to be asking that the Constitution would require us to create a status offense or to think about, in order to be constitutional, it must be a status crime. It just, it's odd. Can you help me feel more comfortable?
Yeah, so the language, the Eighth Amendment language is an offense that reflects irreparable corruption. So there's certainly an emphasis on the offense, and the genesis of that language may be the kind of discomfort you're addressing. I think that that's what the court has given us as our Eighth Amendment mandate that we have to implement. And so, you know, maybe your jury verdict says, does this offense reflect irreparable corruption, as opposed to, do you find the defendant irreparably corrupt, right? So maybe you have.
But if that were true, then all of the things that are characteristics about the offender rather than the offense itself would have to be eliminated from the calculus, right?
No, absolutely not. So that could still be part of the calculus as the allegations in some of these pleadings are consistent with the offender and not the offense, right? So they believe that those characteristics of the particular offender are aggravating such that they justify a finding of irreparable corruption. And so certainly it hasn't been limited to that in practice.
Okay, thank you very much.
Thank you very much.
We've got 1:32.
Thank you. Not a lot of time, but I think we have to recall the standard here, and we have to recall what Montgomery tells us about there is no formal fact-finding requirement. We've talked a lot about this idea of irreparable corruption. Is it a fact that we find? And it's not. It's a moral judgment. It's a conclusion of the court based on each individual offender. So if we do, as my opponent wishes to do, and make irreparable corruption a finding of fact that has to be found before life without parole can be imposed, what does that verdict form look like? It's different for every single defendant, because every defendant as an individual is different, every crime is different. There is no factual finding, and that's exactly why Montgomery tells us that. There's no requirement that we find incorrigibility. There's no requirement that we find irreparable corruption. And
Counsel,
I think
what's your response to opposing counsel's point that Miller and Montgomery make the life without the possibility of parole no longer a potential sort of background norm of this, that we can't think of that as the default sentence, that the default sentence has to be the opposite of that? And
I don't think we can call either sentence a default sentence when you look at our statutory scheme in light of Miller. And I think Justice Viviano talked about it. You go back to the original first-degree murder statute, it tells you the penalty is life without parole, but it qualifies it by saying, except as provided in sections 25 and 25A, which gives you the process to comply with Miller. Miller is about a process. Miller is about giving each individual that chance to show mitigation.
I totally agree. It's just a question of whether the process – go ahead. You go.
I mean, if Miller were just a process, then Montgomery would have come out differently.
No, I don't mean Miller is just
Right?
a procedural. Miller gives us the process to implement the sentencing that gives the substantive guarantee. I don't mean to say the word process in what
I'm sorry.
you're taking as
Yep,
procedural.
I got you hung up. I took
Loaded
some
word,
of
I'm
your
sorry.
time. I give you your seconds back to
No, and it looks like I am out of time, so thank you.
Actually, can I ask a question?
Sure. Yeah.
But can I
It's his
ask
specialty. He likes to wait.
I like to wait just because I have kind of a unique brand of questions.
Okay.
Can I can I ask the Attorney General's office a question?
Of course.
Please.
Yes, Your Honor.
So good morning, and I have to say we always enjoy having you come because you always present beautifully when you
thank
come.
you, Ron.
So it's always a pleasure to have you here.
Now you're in trouble.
Set up.
So I just want to ask you a question as we've kind of been listening to this, and this is just something I've been kind of thinking about. You know, this is really kind of a determination of your office to kind of get involved in this. And I guess my question is, as we kind of ponder this, what is the state's position? What is your office's position as to why you have concerns about letting juries make this decision?
Ultimately, it's not really about my personal judgment, right? I think
No, I
it's the
understand.
Attorney
It's the
General's.
state's
It's really
position.
what the legislature has done. The legislature could have created a jury system, but it didn't. It gave this responsibility to the sentencing court. In fact, Montgomery itself twice uses reference to sentencing court. Now, that's not dispositive. But obviously, we're contemplating this. Well, could be a sentencing judge that's making the decision. And because the legislature has created that scheme, it is a constitutional one. It doesn't run afoul of the Sixth Amendment. In fact, I don't know of any court that has found that this has been litigated lots of places in this country. I don't think there's a single court that has said this has to be a jury determination, because I think that language from Montgomery that says there is no formal fact-finding requirement that's necessary, and incorrigibility is not a fact-finding. There is no presumption of a term of year sentence. The trial court, once the jury verdict comes down, it authorizes a life without parole sentence. The only trigger necessary is the prosecution motion. But once that happens, there is no necessary factual finding. And all these questions that were asked all talk about, because irreparable corruption is an Eighth Amendment concern that is an ultimate value judgment. It's just like saying proportionality. We wouldn't say to the jury, is this the right sentence? Make a proportionality decision. That's not a fact. We could have them make the ultimate moral judgment. We could have created that kind of legislative scheme, but we didn't. So when the Attorney General comes up, what we're really trying to do is really represent the view. When we talk about the legislature, it's not really the legislature, it's the people of the state of Michigan.
No, and I understand, but I guess I'm going to ask you kind of, an additional question as we kind of interpret this and we look to the legislative history and we to look to these types of things. What would you hypothesize as the reason or your concern for why the legislature would feel that this is not something that could be best decided by a jury?
It seems to me that we give our sentencing judges this responsibility in all sorts of cases, right? I mean, that's really how, it's in a way, we have lots of very tough sentences that are going to be imposed. And it is the kind of thing in which we as a people, the state of Michigan, have looked to our judges to make that decision. We're confident Judge Kelly here and Judge Fullerton in the next case are the ones in the best position to make these decisions.
And is that because you feel that a jury would not be able to make those decisions?
I think juries, we could have made a different legislative call, but ultimately that's really at heart a policy judgment, it seems to me. But the idea that it would be improper or somehow inappropriate for us to continue to have confidence in our sentencing judges to make these decisions when they make all of these very hard decisions all the time. It is the thing in which we have entrusted to our sentencing judges. That is the way the whole scheme works. So the idea that we would have them make this decision as well makes perfect sense. I think there are other policy ways of looking at it, but when you ask why the Attorney General has taken this position, it's because that's what the people of the state of Michigan have created.
Counsel, thank you.
Okay, this case will be submitted. Thank you.